going to go through it on our discussions. We're still basing our discussions. Ms. Santons has given us another long thing which we'll have to look at. And there might be things after we've gone through our things that we can then add new things to discuss. But let's go through on our things. And these are the things we discussed with Mrs. Herring and the Swiss delegate and J.J. Allen and others. The next one on our list is CAS. And what we agreed, let's say, which again you can do with what we agreed, is that CAS should be the court for all cases except commercial disputes involving contracts. Providing that there is some, so this is what we agreed with Ruth, with Mrs. Herring, that CAS would be the court in all cases except commercial disputes involving contracts. I.e., if we have a contract with DGT, then that, or with anything else, then we will probably put it to the Swiss courts rather than CAS, because we don't believe that has anything to do with CAS. Obviously, if it's staff contracts, if it's in Russia, it's the Russian law. If it's in Greece, it's the Greek law. Or if, so that's different. So it's really contracts that we make with outside people like DGT and others should be Swiss law rather than CAS. Yes, Morten.
But players and tournaments.
Of course, everything else is CAS. Absolutely everything else. Oh, players. We've never wanted to take players and tournaments out of CAS. What we roughly suggested is that we felt that statutes maybe should be done by the Swiss courts, but we've agreed, okay, that goes through CAS. Provided we've seen what the International Ice Hockey Federation has on their website, which I will read to you now. And that says that member national associations are responsible to ensure that they understand and apply statutes, bylaws, and regulations of the International Ice Hockey Federation and contracts entered into by the International Ice Hockey Federations of which they are party. In the event that they challenge or cause one of their constituent bodies, clubs, teams, players, or officials to challenge the validity of a said statute, bylaw, regulation, contracts, or their interpretation by the International Ice Hockey Federation office, and having exhausted the appeal procedures within the International Ice Hockey Federation, seek arbitration or settlement by a court, then in an event that they are unsuccessful, the member national association shall be held liable for all expenses incurred by the International Ice Hockey Federation in defending the challenge. Notwithstanding the above, in the event of any dispute to the extent of the expenses incurred by the International Ice Hockey Federation, the matter will be resolved by a sole arbitrator agreed by the parties whose decision should be final. Now, that is what they have in their statutes. What we want to change the wording a bit, Jean-Marc has had a bit that we changed some of them, especially the final sentence, which will go to notwithstanding the above, in the event of any dispute to the extent of the liability and or of expenses incurred by the International Ice Hockey Federation, the matter will be resolved by a sole arbitrator agreed by the parties whose decision would be final. Now, what we are also suggesting that if FIDE lost the case, we would then automatically cover their costs, i.e.
It goes both ways.
Works both ways.
But what you quoted now was a very long passage. I don't know if I managed to follow. Are we talking inside self-rule before it goes to court? Or are you referring there to a court decision?
Both.
So the cost you're talking about is the cost awarded by the court then?
No, all costs, International Ice Hockey Federation has it, but all costs of the unsuccessful challenge that liable for all expenses incurred by the International Ice Hockey Federation would be borne by the losing party.
But how can you decide which cost is relevant or not? If the
That's why we have the dispute to the extent of the expenses incurred will be resolved by a sole arbiter agreed by the parties.
Yeah, I didn't see
the no, it'd be agreed by a yeah.
Because I think the problem with the CAS in this respect is that they don't look seriously at the cost.
Yes.
As any regular court will go very seriously through this and award everything that they accept.
Not only, Martin, They are thinking always, okay, the World Federation, not only ours, any World Federation. Okay, this is the rich body, they can afford. You know very well this. You have been there.
I work a lot with labor disputes, and you have exactly the same. The company is always paying because the individual fighting the company, it's not an even match. So it's the same analogy.
Yes.
Of course, to say the truth, Morten. Morten, to say the truth, if a player is the one who sues FIDE, we cannot get anything from the player, you understand? We know this, actually. But it's not the same if it's not a player. So there's any other comment?
Yes.
Yes.
Well,
Develop.
I think we have to find a general picture or where we can insert this additional rule. And what I think is important is to clarify some points. First point, in my opinion, well, we all know that the CAS judgments are very, very, very expensive. The most expensive, probably I can say in the world, but they are an arbitral court, so are really, really expensive. So I think really we have to reduce the number of CAS cases, so how we can reach this objective. I think the first idea was to clarify that only very final decision can be the object of a CAS case. We tried it, I think, this was one of the main points of the rationale of these new rules. I think in the final draft, something probably more have to be added.
Yes.
But if now you will intend to change everything, because in the current draft we have two main courts, so the Swiss civil court, this is clearly less expensive. For example, if we discuss something about electoral procedure and so on, I don't think that it's the same to go in front of an arbitral court. Just the secretariat is very expensive. And but well, if there is a political agreement that all cases concerning FIDE, except commercial contracts, have to go in front of CAS, fine. This is a political situation, a political decision. If you agree, all federations agree. I think, again, I'm a little bit in doubt about these bilateral discussions. I would prefer to have multilateral discussion about this. But well, if there is a common agreement, okay. But have to be clarified, in my opinion, that the only final decision, and have to be clear that there are, for example, electoral commission, final decision, ethics commission, final decision, in other subject matters, General Assembly, final decision. Okay, after we go to the CAS.
Yeah.
Fine. Well, what about liability for expenses? Well, it's clear that this rule is that I read now is have to be changed quite a lot for us, because the first part concerns, for example,
yes,
the application.
I know. I was just quoting them.
Okay. If we have to redraft these in some way, well, their system is there is another arbitration at the end of the first arbitration. That means what will be the arbiter that has to decide on this? If you don't agree this before, and what does it exactly mean, all legal expenses? Because you know it's a great problem. Huh? I don't know. There is a Reich Federation that can spend for 10 lawyers and against maybe another federation that has just one lawyer or no lawyer at all. Is reasonable to have 10 lawyers? And general problem, yes, it's true. CAS usually don't pay too much attention to expenses, but CAS is an arbitral court. That means that if we want, we can add an, I don't remember the technical word in English, an arbitral clause where it's specified how CAS have to evaluate expenses. Because we have not to forget that we give, when we add in our statute one rule where it's written, we go in front of CAS. So this is an arbitral cause.
Yeah.
I apologize for the right technical words, I'm not sure. But well, if in this rule we add something about expenses, something reasonable, because you know how it's written this way, all expenses, is a judge or an arbiter of court that has to decide what is reasonable as all expenses. If not, well, you can say someone can pay for a just stupid idea. We are discussing about statutes. Maybe there will be someone that starts a case against the modification of the statute. Maybe you won, I don't know. How he can start to be paid? To a preliminary memorial concerning this, to other lawyers to attend, people that attend here, all expenses. This is not reasonable. And the parties never will agree about what is reasonable. So it's necessary to have a judge or an arbitral court that has to decide on this point. In my opinion, it would be better to have a better rule that clarify what exactly are the reasonable expenses and who has to decide at this point.
Okay, let's you and me write one.
Yeah,
Martin.
and that's why in all systems that are really working, the court is deciding what they think is the reasonable amount. The problem has been that the CAS has not really understood anything of this, I have to say, I have to admit. But on the other hand, it would not be fair that you come with your 10 lawyers and you present a bill of $2 million. That's not correct either. So we have to find a way, and what I would trust is when the court looks seriously into this and decides we award you €150,000 because that's necessary legal cost. And in Norway, lawyers' bills are cut on a daily basis by the court because the court says this is not necessary.
Okay, I support, personally, it's a good proposal, but I have a procedural and contextual argument here. First of all, procedural one. Okay, let's start from contextual one. Assume that the Turkish Association went to court against the FIDE, and we lost the court case, and we don't have this money we created damage for you. What will happen then? Is it written somewhere?
Yes,
Yeah, it's actually part of democracy, Ali, that you can sue the government, individuals, companies, and it doesn't have a consequence other than you have to pay your cost, and if you can't pay, it can lead to bankruptcy, but it has none whatsoever political agenda.
No, I say what will happen, because there is a...
Forget it.
I'll tell something. Why we try to include such a regulation here? Because exactly what he said now, Morten. We don't want to have federations or individuals that they are ready to sue FIDE for no reason. This is the problem. We want really to think 2 times, 3 times before they go. And this is the main reason, really the main reason that we're trying to include something like this here. We want to discourage people of suing FIDE for no really important reason.
Macro, then let me continue.
And that's why I agree completely with what Morten said.
Okay, let me...
I
understand.
I
understand. Let me continue. Then I make a proposal. If the losing party is not able, the federation is not able to cover the expenses, they should be suspended by their voting rights up to a moment they cover the expenses. There should be a consequence of this, because if you put this and the federation is not able to do it, federation will not be bankrupted. Because it's an institution, it doesn't have properties or something, players, ratings are the assets of the federation, arbiters and the management. Therefore, I propose this first.
The answer is quite simple, I see.
Gary, I show you, after Israel you speak, just because he's trying to answer to what Ali says.
The answer is simple. We consider such a situation
rare.
like a federations, they didn't pay their duties,
Yes.
or with all the consequences.
Okay.
What can we do?
Yes, Gary.
There are a number of issues here. Let me start with the proposed clause that we are borrowing from ice hockey. Yes, I still couldn't get it whether there is a reciprocity. If FIDE loses, is FIDE paying expenses?
That's our idea, yes.
Yes,
Okay,
yes.
that's why I'm clarifying.
Yes.
It's not in their wording. It's
Yeah,
not-
it's right. Now, I actually think that the CAS paid enough attention to the cost, considering the first case when they spent so many months in anticipating that. But we all understand that the greatest potential danger in terms of financial damage to FIDE come only from very hot political disputes. Both cases that were heard by CAS, they were related to one very short period of the elections 2010. So that's why I think that what we're doing now is very important, because if we can agree on terms that would not leave too much room for gaps and loopholes, I doubt it's going to happen again. Why I think CAS is vitally important to keep. First is an image. I think it's any attempt to walk away from CAS, I think, will hurt the image of the organization, because it's seen that we're trying to depart the Olympic family. So that's why even if we want to limit participation of CAS there with the commercial element, I think FIDE should do a good PR job by explaining to federations and to the rest of the world that we are not parting with Lausanne. Also, I think it's important to preserve the rights of the federations, because Swiss courts will be handling cases in French or German, which makes it for many federations virtually impossible to move on. Also, it creates, I think it's some sort of collision with FIDE documents, because all of them are in English. So I think since CAS is ready to hear all the cases in English, I think keeping CAS is important. And
You've agreed to that, Gary.
No. I'm just. I think it's a vital issue, and I hope we can agree on the provisions which will avoid any potential conflict in the future. I still would like the panel and the General Assembly to consider my proposal. I understand, we don't want outsiders to rule the process, but maybe to invite some of them to become part of the electoral committee, whether you like Big Four or not, and to make sure that the candidates are paying legal expenses. I think since this is the biggest potential threat, the biggest conflict will be only at the election. So why not to ask candidates to come up with, as I said, 50,000 Swiss francs against legal expenses, to make sure that it will be supervised, because we'd better have some sort of the supervision within our structures, rather than to start big fights afterwards. So I think it's natural, since we had this experience, just to avoid it and to make sure the candidates will be responsible, not FIDE.
Yeah, what I would like to clarify, Gary, is that in our proposal, it's clear that we don't break the relations with CAS. We go to CAS for everything else, except we say this status, elections and all this. All the other are in CAS, in the original proposal. After the discussion that we had with Mrs. Ruth and others, we said, okay, we go for everything, even status in CAS, if we include this paragraph, except contract. So we're not breaking the relations with CAS. We don't need to make any PR to support from the beginning. We don't need to support what we are doing. Now, 50,000, when the bills are going to 900,000 euros, 50,000 is absolutely nothing. Probably we should go to the proposal of Fiumicino, when in Torino he said, let's everyone put 1 million. This I can understand. This is reasonable, but 50,000 is absolutely nothing.
Macron, sorry, it's nothing for the court. But if you want to hire a consultant just to supervise it, it's more than 100,000 Swiss francs will cover expenses.
No, but we are talking about something else. We don't want to go again.
Yeah, it's just okay. It's I'm
Gary, you go to the previous discussion. But
no,
we had our arguments first of all about principles, not about money. Our arguments were about principles there. Yes, sir.
Okay, my second proposal, we are talking about a case, but why we are discussing, because of our very bad experience. And I made a proposal to General Assembly, okay, it's not to get a slot there to discuss this issue, otherwise nobody would discuss it maybe. So we have to find a way to decrease the number of possibilities to go CAS. Therefore, we should say that there should be a body in FIDE, and we can do it legally as FIDE. I mean, democratically, we can decide this, because there are other international sport organizations I checked before going to CAS, like going to lunch or dinner easily. You have to apply first to General Assembly for some certain issues. And for some certain issues, it's open to CAS. So what I propose, General Assembly should be a buffer between decision and CAS. And we will have time to sit down together. Then we can get idea, like arbitrator from outside, maybe, I don't mind, to get to discuss. Because there are also, I want to enrich it with another example, it's very important. In football, in basketball, and in volleyball, there are dispute resolutions commissions, very authorized, before going to CAS. So because they know that it's stupid expensive CAS, all in international organization and the national organization. So we have to use these means, which is being used by the modern associations. Why we have to spend our money, federation money? Maybe also we should think about that. Federation is totally right. They want to go to CAS. They have totally stupid decision FIDE made, assume, and they cannot go because they are afraid of this cost. So first they have to go to this commission or General Assembly to discuss. So we should protect also the federation.
Yeah,
It's
it's
a defect of
actually,
the ice hockey. That is indeed
yeah, it's actually what Mr. Rivero said before. Final decisions. This is what in our draft, in our proposal, we are talking about final decisions, but there, because we were thinking to go only for chess matters, it goes only for this. It now applies for everything, of course, final decision. What is new, what you say, is that even for elections, somebody should go first to the General Assembly. Now, could be, let's say.
No.
But what is the problem here?
Electoral Commission of General Assembly.
No, he said General Assembly. The Electoral Commission is obvious.
I say body. I don't
Yeah.
know.
So we have created the Electoral Commission for such a reason, to try to have decisions there, not to run. But let's say, what happened last time? 5 vice presidents, they have been nominated, somebody is suing for this. If he has to go first to the General Assembly,
You have to wait.
he has to wait 2 years. And this is the
There's
problem,
no
that
time for this.
we cannot say, okay. For other reasons, yeah, maybe it's possible, yes, but especially when it was a punishment, like to say in the past, you remember, his stupid and all this, yes, yeah, there a cast told him, you should go to General Assembly first. Morten.
Yeah, I think if you look back, the track record of FIDE in CAS is quite good because FIDE hasn't lost a case. So the CAS system
Thank you, Mrs.
and it
Sandberg.
works because you can present the case there. The problem is it has no preventive effect.
Yes.
Because if people are not handed out cost.
Yes.
So it doesn't stop you from suing. That's the real problem.
Yeah.
But I will suggest another solution. Why don't we create a permanent body with professionals, with judges, professors, or whatever, a permanent body outside, where all these fights must be put for decision. I mean, and the parties bear their own cost in presenting it there. And you pay those people a regular sum every year to be this body. Then, when they make a ruling, you can go to the courts, of course, but then you are pretty sure that they have done such a good job that it's a bigger risk moving to the next case. Then we know what this will cost the organization, and it is favorable for the organization
So
to have such a
except
system.
CAS, you are proposing another body.
No, it's
That
FIDE
works
CAS.
much faster.
You know, Morten,
FIDE CAS.
I was saying, we should not allow lawyers to speak in this.
No, but-
Because always they find new business. Unbelievable.
This is the system for the national federations in my country. They have lawyers and whatever. The minute there's such a quarrel, it goes there, they give the decision.
Okay, thank you.
No, I mean, if we look at
It's
that.
serious.
Yeah, no, we'll look at that.
Yeah.
Definitely.
Yeah, just 2 points, Macro. The one is, I think what is important of this clause is it says, having exhausted the appeal procedures within the organization. Now, when the ethics committee makes a decision, it's a decision of first instance. When the electoral commission makes a decision, it's a first, hang on. But then what we're talking about, we want to insert a first tier appeal procedure. Whether you use an external body like Morgan suggests, or whether we form an appeal commission inside before it goes to CAS. But the important, and I would suggest that the General Assembly is not a good body. It is members' federations. They don't have any specialized knowledge about the subject matter of the thing. My second point, just bear in mind that this clause talks about wanting to challenge the validity of any statute, contract, or interpretation. It does not deal with decisions. It only has to do with validity of things. So. So it's also confined. It's not as wide as you might think it is.
No, we're rewriting it.
And just the last point, as a lawyer as well, when you talk about all expenses, and Morgan was saying the normal thing is the court decides about legal expenses. That means the cost of the lawyers. It doesn't mean hotel costs, traveling costs, accommodation costs.
Yeah, we know that.
All of those.
Yeah, we know that. Yeah. And can I point a thing what you said slightly wrong? If it goes to the Ethics Commission, then it can only be appealed to the CAS. There shouldn't be something after the Ethics Commission. The Ethics Commission is the final one in FIDE, end of subject, and what we suggested is the Ethics Commission says this should, in our old thing, that this one should be appealed to the Swiss courts, this one can be appealed to CAS. Now it seems that almost all of it will be appealed to CAS. Okay, that's fine. I mean, but no, the Ethics one must be the final one. We can't have anybody between Ethics and the CAS.
Yes, as linked to this problem as to Morten, it's true that in some other quite important sport federation there is a justice system of first degree appeal court and so on. And for all of the serious federations at least, there is no General Assembly that can overrule a decision of the judicial organ of this federation. And so I think. But well, we discussed this because it's clear. I think it's not. Okay, I am the chairman of this federation, but you know that Ethics Commission final the decision. Just in one case, someone appealing the CAS, but after 1 month he changed his mind. Even some quite serious cases we had recently, we had no appeal in front of the CAS. Probably because the commission is composed, but I hope, quite serious judges or lawyers, and so it's quite a professional job. I know because it's exactly my experience that to work for free is not so pleasant. But well, this is particularly when you are fighting against people that are paying their lawyers quite a lot. Because in the recent cases we have to evaluate the work of quite important and famous lawyers. But well, this is the system, and I think we have no money enough to have a real professional commission to do this. But it's clear, this is will be interesting to discuss, because in the draft of the new statute there are some proposals that change the nature of the Ethics Commission, for example.
If you cut the number of vice presidents, you can finance this.
Okay. No. Well, our request was to have, in the majority of federal of sports federation, people work for free.
Thank
so,
you.
Just to clarify, it's clear that everything is linked. We have to build a system that have to be well constructed, and so. That it will be clear that, for example, electoral commission decisions are final. Ethics commission are final. If you want, you can add the second degree, third degree, what you want. But what is important, you have to have a system with a final decision, that for everybody is a final decision, and only after this final decision you can go to the CAS. Yeah. This way you can reduce the number of cases,
Except, Roberto, except the last sentence of previous part, what you said, like you are totally right. I believe working free is very risky for judges, such as judges in the Ethics Commission. Everything is okay. I clearly support, but there's a problem. You said if we have sources to create a commission to pay for them. I will tell you, if we used to appeals commission for these court cases, I don't think that it will cost us 1.2 million euros. It would be more cheaper, I guess. And we would have money, because he said FIDE doesn't have, no, he says that FIDE doesn't have money to afford such as commission. We would have now 1.2 million euro, and this commission for these two cases could make a, I mean, we have
but
to.
still they can go to cash, so still we will pay them.
Okay, but if the resolution is very